Hello, and welcome to the 8th in our series of video guides for founders and entrepreneurs starting up a business. In this session, we'll be looking at commercial contracts, those that you issue and those that you'll be presented with. And I'll also cover confidentiality arrangements and non-disclosure agreements as a specific subset of commercial agreements. As this is such a wide topic, I'll only be touching on a number of different types of agreements, so do feel free to get in touch with Russell-Cooke for more guidance. For those of you who've been following the series, you will know that we are advising fictional startup Streamzer and their founders Gina and Hans, who have launched or are intending to launch an app. So Streamzer has reached the stage where it has a business structure sorted out, it has secured funding and hired the talented people it needs, as well as protected its brand to the extent possible. Now it's ready to launch its app into the world, but first the founders need to think about the terms they're offering to consumers and other contracts they may need to enter into. Some businesses need to negotiate individual contracts with each of their customers, particularly where there are a small number of high-value contracts, or they may need to contract on terms presented to them by significant customers such as Marks and Spencer's. However, in most cases, a new business will want to have a standard set of terms on which it will contract with customers so that the same terms apply in every case. These terms will cover a range of topics, such as the scope of the deliverables, be they goods or services, price and payment terms, how long the contract lasts for, insurance and risk, and most importantly, liability for loss or damage. A supplier of goods or services will be keen to see limits on their liability so that their risk is manageable, and insurers may insist on this before offering cover. If you're providing goods or services to consumers, those individuals acting in their private capacity rather than businesses, then additional regulations need to be taken into account when drawing up your standard terms of business. In essence, the terms with consumers must be fair in all the circumstances. Layered on top of this are more regulations if you're dealing with consumers at a distance, which usually means online, and this requires certain information to be provided to them and your cancellation and returns policy to be compliant. It's a lot to think about, and it's quite disastrous to get it wrong at this stage, as the mistake will be replicated every time you make a sale and enter into a new contract. So it's worth spending some time and effort to get your standard terms right. One issue you need to think about is how your customers will read and acknowledge their agreement to your terms of business. Thankfully, gone are the days where a business could hide away pages and pages of terms detrimental to consumers and then roll them out when a customer complained. Now you need to be really careful to ensure that customers have had a chance to read the terms, that you've brought any unusual or onerous terms to their attention, often in relation to limits of liability, and that they've specifically indicated their acceptance, such as by clicking a button. This particularly applies where the consumers have had no chance to negotiate terms specific to their own dealings with you. Streamzer has, of course, taken legal advice from excellent lawyers who know what they're talking about and have a robust but fair set of terms which are compliant with distance selling regulations and which are properly incorporated into each customer contract so they can now move forward with confidence. It's very important for a startup business that's likely to need additional funding to get all their contracts in apple pie order. Investors will review these in some detail as part of their due diligence and are far more likely to lend to a company with a good set of commercial agreements than one that has cut corners. There are other types of contract that Streamzer may have to enter into, and these include standard terms that are presented to them, such as their Microsoft licenses. It's worth reviewing these, but they won't be changed, so it's more an information exercise. There may be other contracts, such as software development agreements, which need greater scrutiny and possibly negotiation. Here there are some key terms to look for beyond the price, and these include ownership of intellectual property, as well as liability for poor workmanship. Again, it's very important for a startup business to get these right. If, for example, it transpires your software developer owns the rights in all developments they've made to your software, your business will be worth less and investors are less likely to be interested. Finally, I want to touch on a particular type of commercial agreement that startups may need, and these are confidentiality and non-disclosure agreements. Streamzer has come up with a unique idea for its app, and until it's ready to launch, Gina and Hans don't want others pinching their idea. Although it's difficult to stop copycats, you will stand a better chance if everyone involved in your business, from investors to contractors to staff, are asked to provide confidentiality and non-disclosure undertakings to the business. You don't need to ask everyone to do this. Lawyers and accountants are bound by professional rules relating to confidentiality, and you can confide in them with assurance. For everyone else, including family and friends, I'm afraid to say, an agreement protecting your idea is a very useful tool. Having said that, these types of agreement are notoriously hard to enforce, so information should still only be provided on a need-to-know basis. Obviously, the better the agreement is drafted, the more likely it is that you can enforce it, so seeking advice is money well spent at this early stage. But often it is the psychological impact of having signed a well-drafted confidentiality agreement that will protect your business, rather than your ability to pursue an injunction or other claim through the courts. In addition, it is another agreement that investors will look carefully at. If you have engaged a number of contractors without insisting on confidentiality, then an investor may well feel that your business is more likely to face competition than if you've insisted on tight confidentiality undertakings from everyone. In conclusion, the stage where you start to enter into commercial agreements is a crucial point in the growth trajectory of a startup business. If Streamzer gets it right, then it will make securing investment, fighting off competitors and attracting repeat business that much easier. But get it wrong and the business could be reaping the consequences for many years to come. I hope you found this video and the others in our series useful. If you do want to speak to any of the Russell-Cooke startup team, then please drop me a note on LinkedIn and I'll respond to you. Thank you.